My name is Steve Bright. I'm the President and Senior Counsel of the Southern Center for Human Rights. I've been there for a little over 30 years. I teach at Yale Law School and also the University of Georgia Law School. And ever since 1976, when I became a public defender in Washington, D.C., I've been interested in the representation of poor people accused of crimes. March 18th of this year, 2013, was the 50th anniversary of one of the most celebrated Supreme Court decisions, Gideon versus Wainwright, in which the court said that anybody who could not afford a lawyer in a felony case was entitled to have a lawyer provided for them. A short time after that, the court said any juvenile who's in jeopardy of being institutionalized is entitled to a lawyer. And not long after that, the court said even in misdemeanor cases, in any case where there's a possible loss of liberty, a person is entitled to a lawyer. One would think that if the court said this is what the Sixth Amendment to the Constitution of the United States, the right to counsel, if this is what it means, that the state has to provide a lawyer, that the states would have done that. But Gideon has been treated as an unfunded mandate. And two things that have been powerfully obvious to me on this anniversary this year is first how far we are from doing what Gideon requires, that some courts are just in absolute defiance. Some courts are operating without any lawyers at all. Some courts are operating with only the most perfunctory representation, where people meet a lawyer, speak to him for anywhere from 30 seconds to maybe 10, 15 minutes, plead guilty, get sentenced. That's the only time they see a lawyer. That's the only time they see a judge. I had a young woman write me last May, and she said, I've had these arson charges pending against me for the last 3 years. I'm innocent, I'm not guilty. But I lost my job because of it. I can't get a job because of it. My public defender has told me to plead guilty and take 15 years in prison. And I've told the public defender, I'm not going to do it. I'm not going to plead guilty, first because I'm not guilty, and secondly, she knew something that lawyers should be telling their clients. She wanted to be a nurse, and she said, I'll never be able to get my license. I'll never be able to get a nursing license if I get convicted of arson. But the only thing the public defender could do was put down a guilty plea. They had no ability to prepare for and try an arson case. We took the case. We got pro bono assistance from a lawyer with a lot of experience doing arson cases. And just cut to the chase, we got the charges dismissed. There was no case against her. But for 3 years, this had really just put her life on hold. In fact, one of the things that grabbed me in her letter was she said, I just don't know what to do. She said, I'm living in my car. I'm homeless. I can't make the next payment. I've asked to be put in jail because I'm afraid I'm going to take my own life or die of the conditions of being homeless. What can I do? And of course, it was only serendipity that we took her case. For so many other people who have the very same plight, they're facing charges, and they're represented either by the meet 'em and plead 'em lawyers that I described, or lawyers who are carrying crushing caseloads. So they just can't give the clients the individual attention they need. And when they have the innocent client, in any kind of case, the arson, murder case, robbery, no matter what kind of case, they're not providing representation. One of the things I always say is, you know, there's no such thing as a small case. These are people right on the margins of our society. And when somebody is held and denied bail, even though the charges may be dismissed later on, that can cost them their job, it can cost them their home. In the case of Jacqueline Winburn, a woman in New York who was held and couldn't make bail, didn't have a lawyer, couldn't seek bond review. She couldn't take her husband to dialysis, and as a result, he died. Ultimately, she was released on her personal promise to come back. Ultimately, the charges were dismissed. But how could she have been punished any more severely than to lose her husband? And yet, despite this crisis, despite that we see this all the time in Texas, there's a lawyer who has missed the statute of limitations 3 times for filing a federal habeas corpus in a capital case, 3 capital cases. Those clients lost any federal review, the only kind that matters in Texas because the elected state judges are not going to take that seriously. And yet that lawyer is still, should have been disbarred, still practicing in Houston today. The Texas bar has done nothing. The Texas Court of Criminal Appeals has done nothing. The judges in Houston haven't even taken him off the list of lawyers who can be assigned cases. So he's now handling about 350 cases, including 3 death penalty cases. And that tells you that the judges, everybody, is a part of this. Robert F. Kennedy, when he was the Attorney General of the United States, said the poor person accused of a crime has no lobby. That's exactly right. There's no constituency. Why would the government, whether it's the state governments, which prosecute 95% of the criminal cases and are responsible for 2.1 million of the 2.3 million people in prisons and jails in this country, why would the state or federal government or a local government provide a lawyer to someone that they're trying to convict and fine or imprison or execute to just frustrate that purpose? I mean, there's no incentive. And in fact, what we've seen and what's been so disturbing is that we've seen prosecutors who've tried to prevent funding for public defender offices, tried to keep them from having the structure and the training and the resources that they need to do the job, because of course it gives them a tactical advantage. If you're representing a client against a public defender who's carrying 500 cases, in Miami the caseload's got up to 400, then it's going to be a lot easier. In fact, I think in many parts of this country we no longer have an adversary system. All of the investigation is done by the prosecution. It's done by law enforcement agencies, state crime laboratories, Bureau of Investigations in the state level and so forth, and by the prosecutor's office itself. In almost none of the criminal cases is there any investigation. There are too many cases. Many public defender offices don't even have investigators. Many of the court-appointed lawyers don't have investigators. And there's just not the time and the resources to do it. So basically the prosecution decides what to charge, and there's a wide range. The same behavior can be charged in many different ways. And then most importantly, what plea offer to make, because 95% of the cases are resolved with plea bargains. And the prosecutor will tell you, if you don't take the plea, you're going to get something far worse if you go to trial. And that's true. You pay a terrible trial tax for going to trial if you go to trial and lose. And so the prosecutors are dictating, you know, guilty pleas by manipulating the sentencing guidelines or by filing for mandatory minimums or whatever. They're controlling what the sentence is. But I think the hard thing about getting the states to fund this is just that it frustrates the state's goal in convicting people. Well, we certainly could do it if we chose to do it. I mean, Georgia spends, for just take one example, $1.3 billion on prisons. It could take some of that money and spend it on representation for people. It'd have fewer people in the prisons. So we're way overly incarcerating people. They have the highest incarceration rate of any country in the nation. But we need some leadership. You know, at the time of Gideon, when Gideon's case was pending before the Supreme Court, Walter Mondale and Eddie McCormick in Massachusetts got a group of attorneys generals, 22, to come in on Gideon's side and to say that a poor person accused of a crime does have a right to a lawyer. And that was cited by the Supreme Court in its opinion, so it had quite an impact. But we don't have that kind of leadership anymore that Walter Mondale provided. Now, any effort to increase funding for indigent defense it just doesn't make it through the legislative sausage factory because there's so many other powerful constituencies that are going to get there first. And of course it is true that not only are people in the criminal system losing their freedom and their lives in many of these cases, but we have all these civil cases where people are being deprived of their children, being deprived of their shelter, being provided all sorts of grievous losses and no access to a lawyer at all, none at all. And so you can't really say the legal system is involved in enforcing the rule of law when 90% of the population is priced out. It's the lawyers have priced out 90% of the population from access to the courts. So the courts are very good for moving around the assets of the upper 1%, but in terms of providing justice for the people who need it the most, we're not doing that. I mean, a prime example of that is you can have a person who's in a prison cell who was convicted, maybe innocent, in violation of the Constitution, wasn't sentenced to death, but sentenced, say, to life imprisonment without parole. That person could be being abused or raped every day in that cell. Now, the person could file a habeas corpus to challenge that conviction, but they don't have a right to a lawyer. They certainly could file a civil rights action to get the protection of the Constitution from being assaulted, because nobody is sentenced. People may be sentenced to prison, but they're not sentenced to being raped. But that person has no ability to do that because there are no lawyers available. Who could need a lawyer any more than that prisoner? And yet there's no lawyers available. I tell law students that if you want to take something that you can, as Oliver Wendell Holmes said, wear your heart out in pursuit of the unattainable, that one of the great challenges and one of the great civil rights issues of our time is representation for poor people accused of crimes. The criminal justice system is a part of our society that's been least affected by the civil rights movement. The 2.3 million people in prison are overwhelmingly black and brown and almost all poor. And people can, first of all, every lawyer has to take ownership of this. If we're going to have a monopoly on providing legal services, we have to make sure the system works, particularly when life and liberty are at stake. It doesn't get any more fundamental than that. And so I urge all law students, no matter what they do, whether they're legislators or whether they're policy people or whether they're judges or bar presidents or corporate lawyers or whatever, they've got to take an interest and do something about this. It's a disgrace. It's a disgrace. But I hope some will go even further and become public defenders and go to these public defender offices that exist. We finally, after years of struggle in Georgia now have, and in other states, we have the structure. We have offices where people can be hired and they can be public defenders. But we need good people to go to those offices, because there are two kinds of public defenders. One where it's the employment of last resort for the old, broken down, alcoholic, drug-addicted lawyers. And there are a lot of public defenders like that, I'm sorry to say. And then there are a lot of idealistic, committed, dedicated young people who are coming out of law schools and going into these offices and making them better and making sure that the right to counsel is a reality, at least for their clients. They're going to, like Gideon's Promise, and getting training. And then they're going to Memphis and Mississippi and New Orleans and all these other places. And really, the most hope I have is that the law students will take this on and make this a reality. That is the best hope we have for indigent defense.